Good morning. I'm Rick Hassan. On behalf of the UC Irvine School of Law, I'd like to welcome you to the 8th Annual Supreme Court Term in Review. Each year, we bring together leading scholars, lawyers, journalists, and jurists to consider what the court has done in the past term and what it means for the United States, and what the court is likely to do in the future. But before I begin, I want to thank everyone at UCI Law who made this event possible. You saw the many people working this event, as well as many people behind the scenes, including Dean Song Richardson and Colleen Tarakani and Jillian Henry of the UCI Law staff. It takes many people to put on an event like this, and we appreciate the many members of the UCI Law community supporting today's event. Even before the announcement of Justice Anthony Kennedy's retirement from the Supreme Court, the October 2017 Supreme Court term, which ended last month, was a momentous one. After a year and a half in which the court did little after the death of Justice Antonin Scalia, and as new Justice Neil Gorsuch came onto the court, this term saw major decisions on President Trump's travel ban, the rights of labor unions, free speech, criminal searches, and so much more. It was also a year of momentous non-decisions, including on political gerrymandering and the clash between laws protecting the LGBT community from discrimination and claims of religious liberties. Now, of course, with Justice Kennedy's retirement, the court will change once again. We expect an announcement from the president later today about who might fill that spot, and we can consider what another changing of the guard might mean for the court. We have an all-star panel to sort out our issues today. I will only introduce the speakers briefly because there's a lot to cover and their full biographies are set out in the event program. I'll be introducing our guests from the far end. Our first panelist, Erwin Chemerinsky, is well known to this audience. Erwin Chemerinsky is Dean and Jesse H. Chopert Distinguished Professor of Law at UC Berkeley School of Law. Prior to assuming this position from 2008 to 2017, he was the founding Dean and Distinguished Professor of Law and Raymond Pike Professor of First Amendment Law here at UCI Law. He is one of the nation's leading scholars. I was going to say save your applause to the end, but you preempted me even there. He is one of the nation's leading scholars on constitutional law and so much more. Justice Goodwin Liu is an Associate Justice of the California Supreme Court. He was confirmed to office by a unanimous vote of the California Commission following his appointment by Governor Edmund G. Brown, Jr. Before joining the state's highest court, Justice Liu was Professor of Law at UC Berkeley School of Law. His primary areas of expertise are constitutional law, education law and policy, and the U.S. Supreme Court. Erin Murphy is partner in the Washington, D.C. office of Kirkland & Ellis, LLP. Her practice focuses on Supreme Court, appellate, and constitutional litigation. She's argued 4 cases before the United States Supreme Court, including arguing McCutcheon versus Federal Election Commission, for which she was named American Lawyer's Litigator of the Week, and successfully arguing on behalf of the United States House of Representatives in Texas versus United States. This term, she argued the partisan gerrymandering case on behalf of the Wisconsin legislature in Gill versus Whitford. Alexandra Nadapoff is Professor of Law at UC Irvine School of Law, where she specializes in criminal law and procedure. Professor Nadapoff's scholarship has won numerous awards, including a 2016 Guggenheim Fellowship, the 2013 Law and Society Association Article Prize, and 2 outstanding scholarship awards from the ALS Criminal Justice Section. Her original work on criminal informants has made her a nationally recognized expert. Her book, Snitching, won the 2010 ABA Silver Gavel Award, anonymous mention for books. Nina Totenberg, who's not sitting there, is NPR's award-winning legal affairs correspondent. Her reports air regularly on NPR's critically acclaimed news magazines, All Things Considered, Morning Edition, and Weekend Edition. When I invited Nina to join us this year, she happily accepted, with the caveat that she might have to drop out if there was a Supreme Court nomination during the time of our event. Sure enough, NPR needs Nina in Washington today when President Trump is expected to announce his nomination to the court. I recorded a 12-minute interview with Nina, which we'll be showing a little bit later in today's program, discussing the travel ban case, the retirement of Justice Kennedy, and the future of the Supreme Court. But because Nina's not here for the full discussion, I've asked UCI Law Professor Leah Littman to pinch hit after a wonderful appearance on our panel last summer. Professor Littman researches and writes on constitutional law with a particular focus on federalism and federal post-conviction review. She's a former clerk to Justice Anthony Kennedy and is already widely respected as a national scholar and commentator on the Supreme Court and related issues. Please join me in welcoming our panelists. The plan for the program is as follows. Each panelist will speak for about 7 or so minutes about one of the court's cases this term, as well as a theme from the court. We'll then watch the Nina Totenberg interview. I will then turn to questions and conversations. I will ask questions, including those submitted by the audience on note cards and those submitted on Twitter using the hashtag UCILawSCOTUS. Please keep your questions brief, and more importantly, please keep them questions. And with that in mind, we will start with Erwin.
Thank you. It's wonderful to be home. It's great to be back at UCI Law School. I want to thank Rick for including me in this terrific panel. Rick said we could begin with overall thoughts about the term. I was trying to think of an appropriate title. Maybe it's The Empire Strikes Back. Maybe it's simply elections, or more precisely, the Electoral College matters. The Supreme Court decided 59 signed opinions after brief oral argument. That's the fewest number since 1864. The conservative position prevailed in virtually every major case. One statistic that I find particularly revealing is there were 18 5-4 decisions. In 13 of them, Justice Kennedy joined together with Chief Justice Roberts and Justice Thomas Alito and Gorsuch. In 0 of them did Justice Kennedy join together with Justices Ginsburg, Breyer, Sotomayor, and Kagan. A year ago, when the court was ideologically divided, Justice Kennedy joined with the liberal justices 57% of the time. I think this past term, October term 2017, will be seen as the beginning of a new era on the Supreme Court. There was an era from the 1890s to 1936 when the Supreme Court was very conservative. From 1937 to 1969, there was always a Democratic majority on the court. From 1969 through a term ago, we would always see the court as conservative, but there was a swing justice, Justice Powell, Justice O'Connor, Justice Kennedy, that could lead the court in a liberal direction in some of the key cases. Last term, there was no swing justice. Justice Kennedy stayed solidly with the conservatives, as statistics demonstrated. And from now on, I think, for years to come, maybe decades, there's not going to be a swing justice either. So I think last term, October term 2017, began this new era of a very conservative court. And it's a time of conservative judicial activism. And the case I was assigned to talk about reflects that. It's Janus versus American Federation. It's judicial activism in the sense that it's overturning a long-standing precedent. It's overturning laws that existed in 22 states. And it's the court ruling broadly when it could have ruled narrowly. In 1977, in Abood versus Detroit Board of Education, the Supreme Court reaffirmed that no one can be forced to join a public employees union. But the court said that non-union members can be required to pay the share of the union dues that go to support the collective bargaining activities of the union. The Supreme Court explained that non-union members benefit from collective bargaining. They benefit in their wages, their hours, their working conditions. The court said they shouldn't be able to be free riders. But the court said non-union members can't be required to pay the share of the union dues that go to support the political activities of the unions. The court said that would be impermissible compelled speech. As Justice Kagan pointed out in her dissent, thousands, tens of thousands of labor and management contracts in the public sector have been entered into based on the assumption of Abood being the law. On the last day of opinions, the Supreme Court 5-4 overruled Abood. Justice Alito wrote for the court, joined by Chief Justice Roberts, Justice Kennedy, Justice Thomas, and Justice Gorsuch. Justice Alito said that to require non-union members pay their so-called fair share is impermissible compelled speech. He rejected the argument that we need to prevent people from being free riders. He rejected the argument that in the context of public employment, there are minimal rights of the employees. He rejected the argument that Abood was necessary in order to have labor peace. Justice Kagan wrote a vehement dissent. She said, there's no reason for overruling precedent here. She said, what this reflects is the conservative majority was doing it just because they wanted to do it. So when I say it's judicial activism, notice the court did overrule a 41-year-old precedent. Prior to that day, states could choose for themselves whether to require employees to pay the share of the dues that of collective bargaining, or whether to be right-to-work states. 22 states, including California, required employees to do this. 28 states were right-to-work states. No longer is this left to the political process. The court overturned the laws in all of those 22 states. There were narrow ways the court could have ruled, but it didn't. It chose to rule very broadly. It's going to lead to a great deal of litigation. Just last week, 10 lawsuits were filed around the country arguing that cities and unions should have to reimburse employees who paid their fair share in the past when the law said this was permissible. If these suits succeed, it will bankrupt many unions around the country. At the oral argument, one of the justices suggested that there should be no basis for distinguishing private employee unions from public employee unions. Abood was about public employees. It might be extended. In his opinion for the majority, Justice Alito suggested giving unions the exclusive power to represent employees, to bargain for them, would itself raise serious First Amendment questions. That's the very core of the National Labor Relations Act, exclusive representation and bargaining. And twice in the majority opinion, Justice Alito questions that. So I think that Janus is very much a harbinger of what we're likely to see from the Roberts Court. Justice Kagan in her dissent refers to it as weaponizing the First Amendment. So I guess the conclusion to draw from this case in this term is that if you're politically conservative, this is really a time to celebrate. And if you're liberal, maybe you can just hope that the Supreme Court will continue to decide fewer and fewer cases each year.
Well, if you think about the swing voter on the Supreme Court as the Jedi who's managing all the forces, then we can call this the last Jedi, right? It's a pleasure to be here in Irvine. It's 30 degrees warmer here than it is in the Bay Area. So y'all come on up, okay? I think Erwin so nicely encapsulated many of the themes of the term. I would only add that I think although this term contains in just a mere 59 cases some particularly notable moves by the conservative majority on the court, many of these developments have been in the making for quite some time. If you believe the political scientists who study voting patterns on the court, we are certainly entering an era by some measures as the most conservative court within modern times. And this term was simply kind of the fruition of many other trends that have been occurring. And if I had to describe them, I would say that in the areas of economic regulation, I think that's where the court has moved most aggressively, using constitutional theories as well as various statutory cases to create, I think, a more laissez-faire economy. I think that's probably the easiest way to put it. The Janus case can be put in that bucket. The Epic Systems case about the Federal Arbitration Act can be put in that bucket. And these are all theories that have been in the offing for a long time. The case about abortion rights abortion rights disclosure in California can also be put in that bucket, where the court, I think, has been trying to move in I guess, a deregulatory way. So I think if I had to make any predictions, I would say on these kind of core economic issues about civil rights regulation, campaign finance, the arbitration clauses, disclosure requirements in various forms of ordinary economic legislation, all these things are going to be vulnerable, I think, in the next period, and they have been vulnerable actually for the last 10 years or so. What we didn't see this term yet, which I think is coming, is a big administrative law decision. So the current administration has been in the business of rolling back various regulations that have been enacted in prior administrations, whether it's the environment or labor relations or consumer protection, any number of areas. And the rollbacks must conform to certain kinds of procedural requirements set forth in law. And those challenges are bubbling through the lower courts right now, and I think at some point we will probably see a significant Supreme Court decision testing the degree to which any administration, not just this one, but any administration has to cross the T's and dot the I's in terms of rolling back regulations. So that's still to come. I would say in the criminal procedure area, we will still see a mixed bag of cases. We had a big case this term, the Carpenter case, which I think Sasha will talk about, where sometimes there will be a kind of more libertarian majority put together. This is kind of the area, one of those issues where the horseshoe of the political spectrum kind of left and right kind of meet at the end of the horseshoe. I don't think that's going to go away. I think so liberals and conservatives will agree on some criminal rights protections, especially in the digital age. And I think on key social issues, whether it's abortion, affirmative action, and the like, the court will continue, despite some people's predictions, I think the court will continue to move cautiously. These are the most divisive issues in our society, and the court will, I think, have the opportunity to take some big bites. But as illustrated by a case just this term, which is the one I was assigned to provide a little briefing on, the court did move cautiously, and that's the masterpiece Cakeshop case, in which I think many of you recall, this was a case where a baker named Jack Phillips was asked to make a wedding cake by a same-sex couple in Colorado and refused. And the Colorado Civil Rights Commission found this baker to be in violation of the basic public accommodations law in Colorado. This case was litigated all the way up through the Colorado courts and ended up at the Supreme Court with a majority of the court saying through Justice Kennedy that this was unconstitutional, but not on a very broad theory. It was only unconstitutional because, Justice Kennedy said, the Civil Rights Commission in Colorado expressed hostility to Mr. Phillips's religious claim in the course of considering the balancing between his religious liberty and the basic statutory civil rights of the gay couple. This was a very narrow theory because the court avoided saying anything broad about whether, for example, Mr. Phillips's free speech rights could possibly trump a basic state accommodations law. And indeed, Justice Kennedy wrote that as a general rule, those laws are perfectly constitutional, citing, in fact, a case from the 1960s from the civil rights era in which the very similar kinds of claims had been made against public accommodations laws about lunch counters and racial discrimination. And so in that sense, I think Justice Kennedy sought to quell a dispute that could have been much broader, pitting the claims of gay rights against the claims of freedom of speech, and deferred, in a sense, that bigger debate to later cases, in the hopes, I think, of encouraging society to more amicably, I don't know if that's possible, resolve some of these issues and let these issues bubble around a little longer. So it's a form of avoidance, you might say, but it's also a form of restraint that the court decided not to take a big bite. And in my view, I think that's probably emblematic of how the court will approach a lot of the big social issues while, as I said at the beginning, making much more aggressive moves in the economic sphere.
Thank you, everyone, for having me out here. It's a pleasure. I came out from DC, where I promise you it's actually even less pleasant because you get this plus like extreme absurd humidity. So heat actually seems like a welcome change at this point. I guess my thoughts on what this term reflects and what we can think about for the future lie a little bit in the middle. I mean, I think we saw a kind of some classic examples of the Roberts Court in two ways this year. You know, we saw some very solid moves to the right and with some very, you know, opinions that were very clear-cut in moving in particular directions. And then we had a few cases that, and Masterpiece is certainly one of them, that to me are emblematic of what we've seen a lot on this court over the past decade, which is where you have a very big decision, a very big case that could be a blockbuster case, a very divisive case, and the court works very hard to find a relatively narrow way to resolve the case. And I'm going to talk a bit about another case this term where I think we see that. But you know, it's been a pattern on this court for some time. And another pattern that we've seen on this court that I think we saw came to fruition this year in Janus is that the court has this notion, even in the big cases, you kind of have like a warning shot. I mean, there were two cases where the same majority that ended up coming out where it did in Janus very strongly previewed that that was probably where it was going to come out. But it didn't do it the first time, and it didn't do it the second time. And there's been a number of cases, if you look at that pattern throughout the Roberts Court, where particularly on some of these biggest, most divisive or big constitutional issues, or particularly when being asked to overrule precedent, that's been an approach that we've seen this court take in kind of saying, you know, we find these arguments, a majority of us find them persuasive, but we're not quite there yet. And it'll be interesting to see if that pattern continues in the future. But I certainly think we saw it kind of in its culmination in a case like Janus this year, and then saw it perhaps, you know, in its beginning, I would submit perhaps in the context of Gill v. Whitford, the case that I will talk a bit about involving partisan gerrymandering. This was certainly the classic type of blockbuster case that could have produced a very, very big opinion for the court. The court really hadn't addressed partisan gerrymandering directly for over a decade, and the last time it did so was in a case called Veith, where you had 4 justices on one side saying, we think that partisan gerrymandering claims are not justiciable at all and shouldn't be heard by courts at all. You had 4 justices on the other side saying, we think that they are justiciable, we think they should be heard. Here are some different tests under which they can and should be heard. And in the middle, you had Justice Kennedy say, basically, I really don't like partisan gerrymandering, and I don't think it's a good thing or even necessarily a constitutional thing. At the same time, I really don't like any of the theories that have been put out there for courts addressing partisan gerrymandering claims. And so what he ultimately did is say, I'm going to reject every theory that's been offered so far as to how courts could hear gerrymandering claims, but I'm holding out hope that somebody will come back to me with a new theory, with a limited and precise theory that I'll know when I see it as to how the courts can get involved and address these claims. And that's basically how we got to the case of Gill versus Whitford this year. Some voters up in Wisconsin took him up on the invitation and came up with a theory that is basically rooted in the notion of what they refer to loosely as partisan symmetry. And the basic idea, the argument that has been made in the case relates to, so it starts with the idea that the entire map throughout the state has been drawn in a way that systematically disfavors one party over another. And the argument is that the way that it does so is by providing an asymmetry in how each political party is able to translate its statewide vote totals into statewide seat totals. And at the most basic level, they would say, you know, the map was drawn such that if the Republican Party got 45% of the votes, it would get 55 or 60 seats, whereas if the Democratic Party got 45% of the vote, it would only get 40 seats or fewer. And the principle that they submitted to Justice Kennedy as perhaps this will finally fit the bill was this idea that, you know, each party should have essentially an equal opportunity to translate its vote totals into statewide seat gains in the legislature. Most of the debate in the case was really focused around the idea of whether these claims can be heard by the courts at all, and both sides were asking the court to really resolve that question once and for all of whether courts can hear these claims, whether there is a judicially manageable standard under which courts can decide how much partisan gerrymandering is too much and crosses the constitutional line, and ultimately the court didn't resolve that question. Instead, we ended up with a unanimous result of the court concluding that the plaintiffs in the Gill case didn't have standing to press their claims, that they hadn't demonstrated that they suffered an individual injury with respect to their voting rights that would allow them to challenge the map on a statewide basis. There was a 5-justice majority and a 4-justice concurrence, but they all agreed on that bottom line result. Now, what I think is interesting about this case, and we'll see if it ends up proving to be kind of a classic Roberts Court type decision or not, is you can certainly read the majority opinion in a very narrow way as basically saying there's just a sort of technicality here that they didn't put the right evidence, didn't name the right plaintiffs, just come back to us with a few more people in the case and a little bit more evidence about their own personal experiences, and then you can bring out all the same arguments and we'll address them then. I think you could also very easily read the opinion as basically taking a very big step in the direction of saying, to the extent there's any theory out here for these claims, we are kind of taking off the table the notion that you can bring them on a statewide basis like this, challenging an entire state map and saying that the state map itself was drawn unfairly. If you want to try and do this in the future, come back to us with a very different, much narrower claim that is about how your own voting rights are impacted in your particular district. So it strikes me as kind of a classic Roberts Court case where you can look at it one way and see something narrow, you can look at it one way and see something broad, and I certainly don't think this is an issue that the court is going to be able to not deal with in the next few years, so we will probably find out one way or another, and certainly the fact that we have a different key critical vote, 5th vote in the case, will make quite a bit of difference.
So, Rick, thank you so much for including me in this amazing event. I'm going to do this a little bit differently. I'm going to talk about the case of Carpenter first, and then talk a little bit about what I think it might signify for the court going forward. So Carpenter versus the United States, which, depending on your perspective, might be one of the few bright spots in this past term. It's a 5-4 decision authored by Chief Justice Roberts and joined by all 4 liberal justices. Every conservative justice wrote a lengthy dissent. And the case is about what is called cell site location information, CSLI. It is the record that is generated every time your cell phone connects to a carrier's cell tower. There are thousands of these cell towers all over the country, and our phones automatically connect to these towers multiple times a minute, every time generating a location record, so the tower knows where your phone is. In this particular case, the government obtained months worth of these records for Timothy Carpenter's cell phone, and the court held that that was a search for which the government needed a warrant. Carpenter is the 3rd in a case which we sometimes refer to as the privacy in the digital age cases. In 2012, in United States versus Jones, the court held that when the government placed a GPS tracking device on the defendant's car and then tracked that car for 4 weeks extensively and in detail, that also constituted a search for which the government needed a warrant. And 2 years later, in Riley versus California, in another opinion authored by Chief Justice Roberts, the court held that during a search incident to arrest, the government cannot search your cell phone without a warrant, in distinction from every other container, object, and personal possession that you have on you at the time of arrest. So during an arrest, the police can search your wallet, they can look through your purse, but they can't look through your cell phone without a warrant. So Carpenter builds on these cases. Carpenter embraces Jones's resistance to this notion that the government can track us 24/7, and it also embraces Riley's acknowledgement of the unique and special nature of cell phones and cell phone data. The heart of the Carpenter holding goes to what is known as the third-party doctrine. It's a relatively old doctrine, and ever since 1966, the Supreme Court has held consistently that when we give our information to others, when we speak to others, when we give our records or our documents to third parties, we relinquish our privacy interests in that information, and therefore the government doesn't need a warrant to get that information from those third parties because it's not a search. So in Miller, the court held that the government doesn't need a warrant to get your bank records from your bank, and in Smith it held that the government doesn't need a warrant to get the list of all the phone numbers you've called from your telephone carrier. Carpenter shakes that edifice to a certain extent. On the one hand, the court is very clear that it's not disturbing those, if we want to think of them as analog precedents, the paper document precedents, but it holds that CSLI, these cell phone locational information records, are different. That we do have a reasonable expectation of privacy in what the court calls the whole of our movements, where we are all the time, quoting from Justice Alito's concurrence in Jones, actually, and relying quite heavily on Justice Sotomayor's prescient concurrence in Jones. The court says that these records are special, they're different. We do have a privacy interest in this kind of digital information, and therefore it is a search when the government accesses it, and therefore the government needs to get a warrant for it, even when those records are created by and held by third parties. So this is a big change in third-party doctrine. The court claims that the decision is narrow. It's not deciding anything about other kinds of surveillance, camera surveillance, real-time tracking. It says it's not disturbing third-party doctrine with respect to other kinds of information or deciding anything about other kinds of electronic records, IP addresses, or the numerous data trails that our many smart devices now leave. But in its essence, the court has opened up these questions, permitting a reconsideration of how much privacy do we have as against government tracking of our movements in public, and what kinds of privacy interests might we now retain in records held by third parties. There has been an enormous amount of literature and commentary on the significance of this line of cases, these privacy in the digital age cases, Jones and Riley and now Carpenter, with respect to what they mean for privacy. But I want to take this last minute to think about what they mean for criminal procedure itself, particularly going forward with the new composition of the court. And I want to add maybe a little footnote to Irwin's history of Supreme Court jurisprudence. So the traditional standard story that we tell about criminal procedure, modern criminal procedure was basically invented by the Warren Court in the 1960s with the landmark cases that we're all familiar with, Gideon and Miranda and the exclusionary rule in MAP, and that the court created those neutral general principles with a deep awareness of and an eye on the vulnerable. That the court understood that our criminal justice system is particularly harsh on the poor, that it is especially brutal and unfair to African Americans. And so in the 1960s, it created basically a criminal procedure safety net. A net of rules that apply to everyone, but that has special protective salience for the most disadvantaged, who are, of course, the average resident of our criminal justice process. And we've basically been grappling with the retraction of that model for the last 40 years. These cases are different. The court has made very clear, especially in Carpenter, that it is not concerned so much with the privacy incursions into the lives of the most vulnerable, but as Chief Justice Roberts says several times in Carpenter, these incursions affect everyone, he keeps telling us, namely us. The privileged, the well-educated, the well-resourced, who are not accustomed as are the average resident of the criminal justice process, we are not accustomed to the notion that the police may be lurking behind our daily activities and our daily lives in the ways that these new technologies make possible. And so I want to suggest that we are leaving the era of the criminal procedure safety net, and that we may be entering an era of trickle-down criminal procedure. I'll just stop with that.
Before I turn to questions, we're going to watch the video. And let me just remind those of you watching online, if you have a question for the panel, use the hashtag UCILawSCOTUS on Twitter. Thanks so much, Nina. This is a turning of the tables. Usually it's you interviewing me, so I'm glad I get this chance.
I'm glad you got this chance too, and I'm sorry I can't be there in person, but my bosses would shoot me if I tried to leave town, and I'd be dead and I wouldn't be on your panel anyway.
Well, you're going to be breaking news probably while we're doing this panel. So I thought I'd start with the travel ban, Trump versus Hawaii. And I thought, could you just quickly describe for us what the court did and if anything about that case outcome surprised you?
I have to say that after the oral argument, nothing did surprise me. And I think in a lot of ways, lucky that the lower court struck down his earlier versions of the travel ban, because they were so problematic and so overtly discriminatory in a lot of ways, and so slapdash that the first one, as you may recall, actually banned legal permanent residents who had left the country, for example, to visit relatives or be on vacation. It banned them from re-entering the country. I'm not sure they intended that in the beginning, but that's the way it ended up. And all of that got straightened out over the course of the months, the intervening months. And the administration was able to do what it should have done from the get-go. Now, a lot of people might say that it was just a pretend exercise, but it was an exercise nonetheless. It went through the process of submitting its proposals to the various agencies, having them make comment and make changes accordingly. And it came up with a travel ban that, at least on the surface, was all that the Supreme Court majority required.
And so were you surprised at how strong the dissents were? And
No, I can't say I was, because this is a very emotional topic, and some members of the court felt extremely passionately about it. Justices Sotomayor and Ginsburg wrote separately, and Justice Sotomayor's dissent, an oral dissent from the bench, which up until that time, I don't remember her actually making an oral dissent from the bench. And this one was over 20 minutes long. I was itching to get out of there because I needed to file. And I kept thinking she was going to wrap up and then she'd get another headwind and keep going.
So many of the headlines focused on the immediacy of the travel ban being upheld, but there was big news broken about a very old precedent, Korematsu. How do you think the court majority and dissent differed on that question?
Well, it's my theory, and I have to stress that I know nothing, but it's a sort of informed theory. And if you disagree with me, please tell me. My theory was that Justice Sotomayor, in her dissent, said that this travel ban was akin to Korematsu, the decision that upheld the rounding up and putting in camps of the Japanese internment during World War II, which later evidence showed had no justification, that there really wasn't any national security evidence to justify it. And so a lot of her dissent was about that. And at the end of the Chief Justice's opinion, he explicitly said the court was wrong to uphold the Japanese internment, and we are saying that it's been condemned by the verdict of history, and we're saying that more explicitly today. He never used the word overturn, but I think it's fair to say that this was an explicit overturning of Korematsu. But that was on the last page of his opinion. And I think it was a response to her dissent, that he was really irked by having this decision compared to Korematsu, and that was his rejoinder to it.
I want to turn briefly to Justice Kennedy's concurrence in the travel ban case, because I think some others saw it as his swan song, telling people everyone has to uphold the Constitution and be good to one another. Did you see this as his final message to the country?
Well, in hindsight, maybe. But I'm not even sure that it was that. I think it was a sort of an agonized concurrence that almost everything that he's written about national security has upheld the power of the executive, with the exception to some degree of his decisions that came quite late in the Guantanamo cases. That came, I think, in 2006 and 2008, if I remember correctly. You'll correct me if I'm wrong. But he would have had to repudiate an awful lot of what he's written about deference to executive power on national security questions. But I sort of saw it more as as for Kennedy, a kind of a guttural Hamlet-like scream saying, I really don't like doing this, but I just have to, because it's what I believe in terms of the Constitution, even though it may not be what I believe in terms of humanity.
Do you draw a larger lesson? You refer to the Justice Hamlet, which is a term I think we both used. In terms of his legacy, do you think he'll be seen as the non-decider? Do you think he'll be known for his decisions on gay rights? What is his legacy?
No, I don't think he'll be seen as a non-decider. I just think that Kennedy was a person who did have strong views on a whole bunch of subjects, but he wasn't always willing to get there right away. It took him time. It took him time to get from the first gay marriage, the first gay rights decision, to eventually the decision legalizing same-sex marriage across the United States. It took him, I think, more than a decade or so. It took him about a decade to get from A to Z. And I'm not sure that he was at all sure himself where he was going. I just think he was a more conservative jurist in the sense of he didn't want to do things too quickly, and he didn't go the next step if he didn't have to go the next step. So by the time he specifically overruled the 1986 decision that had upheld making consensual gay sex in the privacy of one's home a crime, it upheld a state law like that. And 2 years later, he joined the court. And by the time he specifically overruled that decision in 2004 or 5, something like that, in Lawrence, I don't think he had yet even thought in any large way about same-sex marriage. I think he really wasn't there yet.
Well, Scalia certainly saw it coming, even if Kennedy didn't.
He did see it coming, and he saw it coming for sure. And I don't think Kennedy did. I just don't think he'd gone there yet.
And so you think on partisan gerrymandering, he just ran out of time before he finally made a decision? Is that why we had this huge buildup with then a big nothing at the end of the term?
I think he hadn't made a decision.
Yeah.
I think if he'd made a decision and really been comfortable with it, he might have done it, but it also might have prevented him from retiring. I mean, I don't know how you can make a huge constitutional ruling like that and then say, oh, you guys deal with consequences.
Right.
That's an odd thing to do. So it's hard to know. It's a chicken and egg proposition, whether you, in your mind's eye, after all, this was argued in at the early part of the term in October. And eventually they rescheduled a second case for January. But presumably they'd been having long discussions about this. And I really do not think he had decided to retire at that moment. And he finally decided to hire clerks, which I don't think he would have done if he didn't think there was at least a very good chance he wasn't going to retire. But for whatever reasons, and I think they were largely personal, I don't think they were part of some even loyalty to this president or any Republican president. I think they were largely personal reasons for leaving at this moment. And they're perfectly legitimate reasons.
Well, before I let you go, I want to turn to the future. And regardless of who it is that President Trump names and whether or not that person is confirmed, eventually someone will join the court. And if it is a Republican nominated person, it's going to put John Roberts in the middle position. Maybe we don't call him the swing justice, but we call him the median justice. What do you think the court's going to be like when Chief Justice Roberts is not only the chief, but also the most important member of the court when it comes to these hot button questions?
I really don't know, because I think he is definitely an incrementalist. We know, for example, that his draft of the opinion in Citizens United originally was just a much more minimalist step. And it was Justice Kennedy who wrote the broad decision, essentially repudiating a century of legal understandings about whether Congress could regulate campaign money in the manner that it had for a long time. But Kennedy had 4 votes. He was the 5th. Roberts was the 5th vote. And he probably thought to himself, well, I'm probably going to get there anyway. And he went along with Kennedy's vision of the First Amendment in that case. And I have no idea. My suspicion is that he will be pulled more to the right, not to the left, because that's his natural instinct. And, Kennedy, at the time he announced his retirement, believed that rights once established will not be abrogated, that the court will not go back on those rights. I'm not so sure that's true, but I think it was his comfort. And I would not predict where this court is going.
Well, on that note, we'll be watching your reporting in the days, weeks, and years ahead. Thank you so much for joining us today, and good luck as the announcement gets made.
Thanks so much. Have a good panel.
Bye-bye.
Bye.
Okay, so we're turning now to Q&A. I have some audience questions, and I think I'm going to be getting some more, as well as some questions on Twitter. Literally, the question on this card is, what the hell is going on? But rather than start with that one, I'm going to start with some of the material I covered near the end with Nina, and I'm going to start with Leah on the question of what was Justice Kennedy's legacy, either in a particular area or generally, and what does his retirement mean for the court in a larger sense?
I think it is hard to discuss Justice Kennedy's legacy just looking back without considering what might come. And you can think about Justice Kennedy's legacy either in a more general sense or as tied to certain substantive areas. So as Erwin was alluding to, part of Justice Kennedy's legacy was being in the kind of middle of the court and occupying a position where there was always some chance that the liberals or the conservatives had some chance of prevailing before the court on major social and political issues of high visibility. That legacy is gone. That's just not going to exist at the court in the near future. You can also think of his legacy as something like you weren't quite sure how he was going to come out. Maybe that prevented both groups from advocating for positions that were more aggressive than they would have done, knowing that they had to kind of temper their position to potentially get Justice Kennedy's vote. That's also going to disappear. The new median is now Chief Justice Roberts, and as people have suggested, he is further to the right than Justice Kennedy is is on some number of important issues. You can also think about his legacy on particular substantive areas. There, I think his legacy is perhaps more secure. When you think about things like the First Amendment and protections for free speech, I don't see that direction of the court really changing in the near or longer-ish future. Other areas are perhaps more uncertain. I think I agree with Justice Liu that the court is unlikely to proceed very rapidly in areas like abortion, for example, but I do think you are going to see some of the justices' decisions, whether it's Casey or Whole Women's Health versus Hellerstedt, steadily chipped away over time. And other areas, there might be more rapid change than those areas, but I think it just depends how you define his legacy as to whether you think, what you think his legacy is going to be and whether it's going to endure.
One of the things that Justice Kennedy would say is, I don't swing, the cases do. And I thought that was an interesting perspective. Erwin?
I'm much less sanguine than Goodwin Liu or Nita Totenberg, Leah Littman, that the court's going to go incrementally with regard to the most hot-button issues like affirmative action and abortion. These are the areas where conservatives have long had an agenda. Now they finally have 5 votes. I think you only have to read Chief Justice Roberts' majority opinion in Parents Involved in Community Schools from 2007 to see a strong hostility to any form of affirmative action. With regard to abortion, maybe the court will simply uphold every state law regulating abortion and kill Roe by 1,000 cuts. But again, my sense is this has too long been the conservative agenda. When they've got 5 votes, they are going to overrule Roe. But I also think you can see the effect of Kennedy leaving by focusing on 2 of the cases that were talked about, Masterpiece Cake and Gill versus Whitford. In both this term, the conservative position prevailed on narrow grounds. The Baker won. The court didn't strike down the Wisconsin gerrymandering law. Now think about what happens when those issues come in the future. Without Justice Kennedy, I don't see a 5th vote to say that a state can force a business to serve customers even when it violates the owner's religious beliefs. I don't see, with Justice Kennedy gone, a 5th vote to find that partisan gerrymandering is unconstitutional. So losing Justice Kennedy in these areas, like so many, really cuts off any possibility of liberals winning for years to come.
Justice Liu?
I think that it will be very interesting in the next period to see how Chief Justice Roberts evolves. I think Leah made several good points about the institutional effect of having a swing voter, and if there is any person on the court who should be concerned about the institution, it is the Chief Justice of the United States. I think that it is, of course, true that that Chief Justice Roberts' instincts are very much aligned with the conservative side. On the other hand, he cast the vote in the Obamacare case twice. Essentially, I took that as a message of him saying, don't bring these cases to our court because you're putting us in a horrible position, and we don't. And he wrote, I think, in quite clear language in those cases, these are political issues. Don't bring them here. And this, of course, did not endear him to the conservatives, and they will never forgive him for these votes. But I think that is revealing of certain kinds of institutional sensibilities. That is not to say, of course, that he hasn't taken some very aggressive steps. He wrote the Shelby County decision on the Voting Rights Act, and I think he wrote a very full-throated decision in the Trump versus Hawaii case, which surprised me, quite frankly, that he took as aggressive a position as he did. But keep in mind that even on issues like affirmative action, it's one thing to be in dissent. I mean, if you go back to the early days of Justice Kennedy's tenure, he wrote in the Metro Broadcasting case in 1990, likening race-based considerations in the awarding of licenses to Nazism, to all kinds of, to apartheid. And then, in just 2 years ago, in the Fisher case, he upheld the affirmative action policy of the University of Texas. So people do travel and people do move based on their institutional position on the court. And I think if there's one person who should be prone to those kinds of influences, it is the Chief Justice.
One thing that I saw over the weekend, I think there was a piece by Walter Olson in the Wall Street Journal editorial pages, and then this was on the Volokh conspiracy, is the idea that same-sex marriage is safe. The Roberts Court's not going to touch that, unlike abortion, where death by 1,000 cuts. I'm not sure where this confidence comes from, but I'm wondering if people on the panel share that view or think that the court could move in a different direction on the question of same-sex marriage issues as well.
So I'll just make it. I don't think the court will formally overrule or denounce Obergefell. You know, part of the Republican Party platform of 2016 was appointing judges who would overrule Roe, Obergefell, and a few other cases.
Just explain what Obergefell is.
Obergefell is the case that said states can't refuse to offer marriage licenses to same-sex couples. And I don't see the court formally going back on that. However, what I do see is there are a bunch of exceptions written into Obergefell, and Obergefell's rationale is not extended to prohibit other forms of state or private discrimination against LGBTQ individuals. So the exceptions would be cases like Masterpiece Cakeshop, where the court recognizes either a right of free speech or a right of religious liberty to refuse to offer marriage licenses, or to refuse to allow same-sex couples to adopt, or refuse to offer medical services to same-sex couples. So they can cut back at Obergefell without formally saying states can't refuse to offer marriage licenses to same-sex couples. And then I also just don't see any 5 justices in the near future on the court saying states can't discriminate against same-sex couples in employment or the provision of other social services. So Obergefell will be limited, not formally overruled, but states will not be permitted to refuse to deny marriage licenses to same-sex couples, again, except for some perhaps religious objectors.
I thought that John Roberts was going to be in the majority in Obergefell in saying that state laws prohibiting same-sex marriage are unconstitutional. I thought he would want to be on the right side of history on this issue, and there's no doubt where history is going. Instead, John Roberts wrote a vehement dissent in Obergefell, and to my knowledge, it's the only dissent he's ever read from the bench. Also, you had separate dissents by Justices Scalia, Thomas, and Alito. A year ago, the Supreme Court handed down a per curiam opinion in a case called Pavon versus Smith. It was about an Arkansas law that said that when a same-sex couple had a child, they couldn't put both spouses' name on the birth certificate. Justice Gorsuch wrote a very strong dissent, joined by Justices Thomas and Alito. And in it, I think Justice Gorsuch clearly suggested that at least these 3 justices would vote to overrule Obergefell if they had the opportunity to do so. So given Chief Justice Roberts' opinion, given that, I'm less sanguine. I'm by nature an optimist, but it's hard to feel other than pessimism at the moment.
Can I just briefly respond? I think that the chief is somewhat of an institutionalist, and he does not get to overrule, and he just would not overrule every single case of Justice Kennedy's or of the Warren courts that he disagrees with. And so he will have to make some decisions because he doesn't want to be the Chief Justice that just undid the last 70 years of jurisprudence. And so I just don't think Obergefell rises to the level of, say, some affirmative action cases that I think he is more likely to overrule than others.
Aaron, I want to ask you about what comes after the court decides that they're not going to police partisan gerrymandering. Because it sounds like that's where I think you are, and Erwin, and I think that's where I am too. That most likely whoever gets appointed by, whoever gets confirmed by the Senate will be that 5th vote. Assume that happens. Do you think that the precedent from 2015 out of Arizona is in danger? And let me just explain this precedent. This was a case where voters had passed an initiative which would create a redistricting commission, just like we did in California. And the question presented in that case was as to congressional districting, where the Constitution gives state legislatures the power to pass rules subject to congressional override for running congressional elections, whether it violated the state legislature's power by creating a commission through an initiative. Chief Justice Roberts was in a dissent in that case. Do you think that precedent's in danger? What would that mean going forward in terms of redistricting reform?
Yeah, it doesn't seem super likely to me that, I don't think if the court goes in the direction of holding that partisan gerrymandering claims are non-justiciable, I don't think that's, part of some vast right-wing, agenda to move all of election law to the right such that they would start going back and changing decisions like that decision that's only, a few years old. Obviously, it was one that the court was very divided on. I mean, cards on the table, we represented, the losing party. So, I certainly have a lot of sympathy for where the Chief Justice came out in that case. But I think the partisan gerrymandering issue is is a little bit different because it is really more, I think, particularly in the eyes of someone like the Chief Justice, it is about the courts and the role of the courts. And this is such a strong strain of his jurisprudence in so many areas, thinking about what he perceives as the appropriate role of the courts. And that's really what that case is all about, is whether, are the courts the right institutional body to be policing this. I think that the issues with respect to independent commissions versus the legislature, I mean, that yes, it's about who's the right body to be doing election law, but I think it's quite different from the basic animating principle that is going on in partisan gerrymandering. I mean, that said, it was interesting at the argument in Gill to hear Justice Gorsuch ask a question that, suggested maybe there's a whole lot of these election law cases, and maybe not just partisan gerrymandering, but other areas of gerrymandering and redistricting that are also not the business of courts. And certainly we've had some justices in the past who've taken that position. So that's been a divisive issue on the court for some time, and I'm sure it will continue to be.
So it sounds like both you and Leah see the fact that the Chief Justice might not only be the median justice, but he also has institutional interests as a Chief Justice, might temper him from doing things that he might otherwise vote to do if he were just any justice. Am I reading you correctly?
I mean, I think if you look at his history on the court, you see that time and again. I think when you look at a number of his opinions across a number of areas, that you see, that there is a driving institutionalism and a sense of incrementalism and a sense of, if we can find compromise, let's find compromise. I'm not saying that's where he ends up in all cases, and certainly over time when you compromise and then the same issue comes back up 1 year later, 2 years later, 3 years later, at a certain point, the court ends up in a different place. But I don't think that that's something that was driven by, we need to keep Justice Kennedy happy. I think that is actually a truly driving part of how the Chief Justice is as a justice and is as a jurist.
Justice Lou, you were going to say something.
I just wanted to maybe elaborate just a little bit more on the partisan gerrymandering issue, to say that the institutional concerns about the role of the court are very much central in the framing of that debate. And I just wanted to add that from the dissenters' perspective, well, I don't want to call them dissenters, but for the justices who would decide this issue, Justice Kagan, I think, in the Gill case, makes a very strong, clear statement that it's actually only the court that can address this problem. Because the nature of that problem is the fox guarding the henhouse. It is the political branches of government benefiting themselves through the political process. Normally we say, well, in constitutional issues, hands off, because the courts can exercise some restraint. The political process can work itself out through a diversity of approaches and whatnot, and the citizens should be able to decide through their vote. This is a process through which legislatures try to lock in their existing advantages, and the claim is that they are depriving majorities of voters, or in particular districts, or across the state, or they're diluting voting strength of voters so that they don't actually reflect their power as a democracy should. Now, of course, that gets into very difficult issues about political theory and what exactly the representative democracy is supposed to be. But it's important, I think, to appreciate that from the other side of this issue, the claim is being made that really it's the court needing to step in, not just that they kind of should or they kind of electively could, but Justice Kagan makes a strong pitch that they absolutely must, because they are the only institution in America that can address this problem, because the political branches have essentially locked it in for themselves.
Sasha, I want to turn back to some of the points you made earlier about the Roberts Court, the trickle-down theory that you ended with, and just try and have you flesh that out a little more, and also think about, if I think about Justice Scalia's legacy, for example, there were some areas where he was very supportive of criminal defendants' rights, such as the Confrontation Clause, and to some extent with searches, and other areas where he was, say, on the death penalty, on the war on terror, on the exclusionary rule, he was not very pro-defendant. How do you see the court shaping up in this area, and does Carpenter show us some kind of bifurcation in the court's approach, or is this the direction you think where left and right can come together?
So it's, in criminal justice, it's always worth remembering where we're starting from. So criminal justice in this country is largely a state and local affair. Federal cases make up a tiny percentage of our criminal system, less than 5%. And the court accorded an enormous amount of discretion to state and local legislators, law enforcement. So is essentially laissez-faire. And every once in a while, we see the court step out of that mold. So we saw Justice Scalia, particularly in the search and seizure arena, advocate for a more interventionist position. No, we're not going to let the police do that. No, we're not going to let the government do that, in the vein, of course, of Carpenter. But with the loss of Justice Kennedy, I think that those interventions are going to be few and far between. So Justice Kennedy was famously interested in some very high-profile aspects of the American, high-profile dysfunctions of the American criminal justice system. He wrote Roper, which was the case that struck down the juvenile death penalty. He wrote Brown versus Plata here in California, the decarceration case. Chief Justice Roberts dissented from Plata. So I think what we can look forward to is a hands-off, deferential posture towards the state of the American criminal justice as it is. So the court will not intervene in mass incarceration. It will not intervene in the racial skew of the criminal system as we currently have it. The death penalty, I hate to call it reform, but adjustments that we've had to date are going to stall. I think of particular note and disappointment is something we thought might happen that is now not going to happen. Justice Kennedy wrote two very important decisions in 2012, Lafler versus Cooper and Missouri versus Frye, which for the first time the court acknowledged that 95% of all the criminal convictions in this country are the result of a plea, not a trial. This is essentially a market. And until those cases, the court had been, again, laissez-faire with respect to that market, and Justice Kennedy weighed in to say that this was an arena of potential constitutional regulation. Chief Justice Roberts dissented from both those opinions, so I think that market is going to continue to proceed unfettered.
Let me ask a very broad question for all of you, which is, we tend in this country to look to the Supreme Court to solve some of our difficult social problems. And it may be that the court is not going to do that going forward, or not do it in the same way. To what extent are there other avenues for achieving goals besides through litigation in the US Supreme Court? I'm thinking of, for example, Florida has a ballot measure that will restore felon voting rights if it passes. The use of state courts, as we saw in the Pennsylvania gerrymandering case where the state constitution was used. Is there an over-reliance or over-fetishization of the Supreme Court?
Well, I'll take that one.
Sorry, softballs for the...
Since in my field that's clearly true in criminal justice, because it is so profoundly a state and local matter, the Supreme Court decisions hold an outsized, sort of cast an outsized shadow, but the real action is taking place state and locally, and there are very powerful movements for reform in decarceration, in bail, in the right to counsel, and all taking place at the local level. So I think going forward, the hope will be that the Supreme Court will not put a cap on those efforts, but permit them to proceed.
Well, of course, I sit on a state court, and we're open for business. So I think that I think there's some grain of truth to the general point, I think, Rick, that you're driving at, that our legal culture does tend to focus on the activity of one court. And obviously, the United States Supreme Court is hugely important in American life, both for the decisions that it renders, as this term amply demonstrates, but also, I think, symbolically in terms of our understanding of the structure of government, the role of an independent judiciary, the nature of the work that judges do. I sometimes worry a little bit that what we observe in the media and then in our public and legal culture generally, is that we come to think about the judiciary writ large as defined by what we observe about that one court. That one court can only carry so much weight in the sense that so many important issues are put there, so much political focus is put there, so much spinning and commentary and prognostication, as we have done today, is put there. And this, I worry about it because actually there are many other judges in America, and there are 50 plus one other state high courts in America, and there are hundreds of state and federal judges on lower courts who are just doing the workaday work of judging. I think, if I may say so, in a fairly impartial, objective, professional manner. And you would never sort of think about this as the image of the judiciary because we are so conditioned by what we think about the one court. And I mean, fair or not fair, I think the commentary about that court tends to polarize us. And I think we miss a bigger picture, which is that in America we have many, many institutions. As Justice Kennedy, one of his legacy quotes, I think, is that the framers of our Constitution, one of the geniuses was that they split the atom of sovereignty. They created a federal system where, and as Madison said, that provided a double security because not only do we have a divide between federal and state governments, but we also have a division within each of those governments of divided powers, legislative, executive, and judicial. And so the entire theory of government that we have in this country is that no one institution at any one level is supposed to control everything. That is the entire structure of our government, is to diversify and divide and separate power in all kinds of ways. And I think that those propositions are being put to the test right now. And so I would say the same thing about our court, as the U.S. Supreme Court, as any organ of government, is that not all the action happens in just one place because our system was created for it to happen in a lot of different places.
Goodwin is obviously correct, but I also think it's a very complicated story. There are the places where the Supreme Court won't let the political process or the state courts operate. Take the area of campaign finance. There's really very little that the political process or state courts can do when the Supreme Court has said that any limit on expenditures, including by corporations, violates the First Amendment. Or the case that I talked about, Janus, the Supreme Court said that the states no longer can require that public employees pay the share of the dues that go to support collective bargaining. The court's taken that out of the political process. It's taken out of the courts. Also, of course, we exalt the importance of the political process. We're a democracy. But there's places where the political process doesn't work. When's the last time a state legislature adopted a law to expand the rights of criminal defendants? When's the last time a state legislature expanded the rights of prisoners? I think the footnote in Caroline Products is right. When it comes to the so-called discrete and insular minorities, it's often the courts or nothing. And finally, in terms of state courts, in 1977, William Brennan wrote an article in the Harvard Law Review about the importance of turning to state constitutional law. And this will be ever more important in the years ahead to expand rights and equality. But keep in mind that then we have to accept as a country there's going to be tremendous differences across the country in the rights that people possess. If Roe gets overruled, as I fear it will, abortion will be illegal in about half of the states. About half of the states it will be protected. What it will then mean is that poor women and teenagers are the ones who aren't going to be able to get abortions. So yes, we can turn to state courts, but we have to accept then that some state courts will protect rights, and some state courts especially with elected judges, just won't.
What about the political process in those states?
Let me go back in history to Brown versus Board of Education. How long would it have been for elected judges in the South to find segregation to be unconstitutional? How long would it have been for state legislatures in the South to do that? When you come to abortion rights, for example, I think again, there's been places like California where abortion will remain legal, but I don't see in most of the southern states or some other states abortion being legal. And then we just have to accept the consequences of some states possessing rights and people in other states not having those rights.
Could I add a bit? I think these are all excellent points, and it gets us into some interesting historical data. I would just offer one data point about Brown versus Board of Education, because I have been very interested in this issue about judicial federalism for some time, given sort of where I sit now. Interestingly, Brown, which is kind of the emblem of sort of the triumph of federal courts and federal law over the recalcitrant states. I think there is something to that story, of course. Brown, I think you'll remember, some of you who have studied the history remember that there were 4 consolidated cases in the Brown decision. There was a Kansas case, South Carolina, Virginia, and Delaware. The Kansas, South Carolina, and Virginia cases came to the U.S. Supreme Court from federal district courts in those 3 jurisdictions upholding segregated schooling. Those cases, those courts and their judgments were all reversed by Brown. The only case that was affirmed in the Brown decision was the Delaware case, Gebhardt versus Belton, which was a decision by the Delaware Supreme Court holding unconstitutional under the separate but equal standard, because that was the operative standard at the time. But that court expressed impatience with the pace of equalization of school facilities and ordered this integration of black school children into white schools in Delaware, and that judgment was affirmed in Brown. So Brown reversed 3 federal district court decisions, affirmed 1 state court decision. And I think that should give us a little bit of insight into the idea that it's true, I think, what Erwin says. I think we would have been waiting a long time for state court judges in the South to hold segregation unconstitutional, but we also would have waited a long time for federal district court judges, likewise, in those states to do the same. So I would just offer that as a counterpoint to the what is sometimes called in the legal canon the myth of parity problem. State and federal judges, I think, throughout our history have been, I think, working on the same enterprise, often quite unevenly, and it's more difficult than one might think to make generalizations about them.
Here's another softball question. Is it possible, and I'll add desirable, to increase the court from 9 justices to 11 justices? And this, there's been talk of this a lot lately as this nomination goes forward. Quiet panel. Does it depend on who controls the Congress? All right. No one wants to weigh in? I can go to the next question.
Feeling the need to answer the question. I think everyone here knows the number of justices is not set in the Constitution. It's set by statute. It increased over the course of the 19th century every time the country expanded until it got to 10 justices. Congress didn't want Andrew Johnson to be able to fill a vacancy, so reduced it to 9. President Roosevelt tried to change that. It was very controversial. It remained 9. There's nothing magical about the number 9. I could easily imagine if there's a Democratic president in 2020 and a Democratic Congress, they will seriously think about the possibility of increasing the number of justices. Now, of course, there's then no stopping point, because if the Democrats can increase to 11 or 13, if there's then a Republican president and a Republican Congress, they can increase the number again. I have no prediction of whether it's likely to happen, given the long tradition now of 9, but I think it will be very seriously considered in 2020 if there's a Democratic president and a Democratic Congress.
There are a number of questions in this pile about the Mueller investigation, and let me ask one that's Supreme Court related. Do you think it would be appropriate for the next justice, if she or he is nominated by Trump and confirmed by the Senate, to agree to recuse from any cases that might make it to the court involving that investigation. Some stumpers for the panel today.
It's a hard question to answer because, in United States versus Nixon, then Justice Rehnquist, who then became Chief Justice Rehnquist, recused, but he recused because he had worked in the Department of Justice, in the Nixon Department of Justice. This is a little bit different because none of the prospective nominees have worked in the president's administration. They would instead just be selected by a president for whom there is some possibility that he would subsequently be indicted. I think that the intuition or desire to have that person recused stems from things that we kind of assume, maybe not unreasonably, that the president and his or her team selecting judges might care about. Like, they have strong visions of executive power. They are looking for nominees who share the same. It's not clear if they are actively looking for nominees who think that presidents can't be indicted. I think that's far less clear, and I think it makes some people uncomfortable that that possibility exists and that you have the situation in which the president and his close circle is being investigated, and that case might eventually make its way to the Supreme Court, and that the president is choosing a person who will decide that. But I just don't know that there is anything besides discomfort and the general unseemliness of how this administration conducts its business by looking to advance its own personal interest, often not for public-minded reasons, that there would be like grounds to suggest a justice would need to recuse.
Okay. Let me ask one more question from the cards before I'm going to ask each of you to think, as you can start thinking now, about what we'll be talking about at the 15th annual Supreme Court term in review, which hopefully you'll all be returning to. But before we get to that, Justice Liu had mentioned a case briefly, the abortion counseling case Becerra. And the question there is, what effect is this going to have on compelled professional speech, such as Surgeon General warnings on tobacco and alcohol products? I don't know if Justice Liu wants to handle that or anyone on the panel.
Well, I think this does dovetail with the theme that I started with, which is that in the area of economic regulation, there have been a number of creative challenges to those regulations over the years. And if you think about the array, and Justice Breyer's dissent in the Becerra case discusses this, the tremendous array of just ordinary labeling requirements that we have, whether it's nutritional labeling on cereal boxes, to disclosures that have to be made at the hospital, to drug labeling of all kinds. All of these things impose certain kinds of, you might call them, compelled speech requirements on industry. And if these become subject to use legal speak, to some form of heightened scrutiny, which means the contrast is between a standard that just says, well, if there's any conceivable rational basis for why this labeling requirement exists, whether it's public health or it's public safety or whatever reason, that's good enough. The court isn't going to meddle using a weapon of constitutional theory in legislative choices that are essentially about how to best regulate the economy, as opposed to a standard that says the legislative body needs to have a really good reason for this, and that reason has to be documented, it has to be empirically substantiated, and the labeling requirement or disclosure requirement that it chooses has to be tailored in some way to that objective. Well, that becomes a much harder thing to sustain, in part because we have to think about economic regulation, for better or for worse, as largely, in the legislative domain, a series of compromises. You have lots of groups going to legislatures, whether it's Congress or our state legislature. They want different things, of course they do, and they're just, there's going to be compromise, there's going to be horse trading, there's going to be log rolling, and you get legislative product that regulates the economy in, you might say, sometimes partial, sometimes haphazard, sometimes obviously compromised ways. But that's because that's the nature of the legislative process. And it had long been thought, I think, to go back to Irwin's comment about the Carolean products footnote, that so long as the burdens that are being borne by regulation are not being borne by vulnerable classes of people in society, In other words, structurally disadvantaged groups, like certain racial groups, or perennial losers in the political process, then the wheel will turn. Politics is a very variable thing, and you lose one day, you win another, and so the courts should generally have a hands-off attitude toward these kinds of economic regulations. I fear that era is already beginning to be chipped away at, and if the Becerra case is a harbinger of things to come, we're going to see much more aggressive challenges being made on constitutional theory grounds, whether it's First Amendment, due process, or something else, that takes us to some semblance of what the court purported to repudiate years ago with Lochner versus New York.
Okay, we only have about 5 minutes left, so just very briefly, if each of you can just give us a thought about what things might look like 7, 8 years down the line in your area or any area. What do we, and we can kind of we can work our way down the line here.
So I think in 7 or 8 years from now, we will be doing two things. One, we will be arguing about whether Roe has been practically overruled, even if not formally. And second, we will be looking back on the last 7 to 8 years and picking up on some of the hints that Aaron and others have alluded that the court occasionally drops. Precedents it has started to push on, limit, and signal that it is open to overruling, and we will be discovering new areas in which the law might change in the near future.
I think in 7 or 8 years, the court is going to be hard-pressed to hang on to its traditional deference to law enforcement in the light of the enormous power that the new technologies are going to confer, not just on government, but on the private sector and the private sector's ability to cooperate with government to make that kind of surveillance and information about millions and millions of people available to the government. So I think that to the extent that there is any trickle-down criminal procedure going on, I think the court is going to have to rethink whether its historical trust in the limits on the government's ability to intrude into our lives, and whether it's comfortable with that as applied to them.
I think in 7 or 8 years, we'll probably still continue to see from this court a really, really strong interest in the First Amendment, and in lots of different ways and in lots of different areas. And and I think it'll be interesting to see. That's always an area that moves around a little bit depending on the makeup of the court. But I think it'll be interesting to see some of the ways that have been discussed, how that will perhaps find its way into some different areas of the court's jurisprudence that are a little less traditional speech jurisprudence.
Well, in 7 to 8 years, we'll have a good time discussing the 15-member Supreme Court that we'll have at that point. It'll take longer to discuss because there'll be 15 people to talk about. No, actually, I would like to offer a different perspective, which is that, so I clerked on the court the year of the Bush versus Gore decision. And if you were sort of on the more progressive side of politics at the time, that side sort of thought that this was the ultimate power grab by the U.S. Supreme Court, and all was lost, and it was just sort of misery and despondency, I think, on that side. And then 8 years later, the nation elected the first black president of the United States. So the wheel of history turns in unpredictable and sometimes rather swift ways, at least in the American experience. So I actually wouldn't hazard any strong predictions about what we'll see in 7 or 8 years, because that's actually in the American experience a fairly long time.
Clarence Thomas is 70 years old. Samuel Alito is 68. John Roberts is 63. Neil Gorsuch is 50. All the nominees who are being talked about are in their 40s or 50s. So absent something unforeseen, it's easy to imagine these 5 justices being there 7 or 8 years from now. This is the conservative majority the conservatives have dreamed of for decades. So what's their agenda? Obliterating any notion of a wall separating church and state, allowing much more religion in government and government support for religion, allowing the free exercise clause to be used for people to discriminate against others, much more robust protection for gun rights under the Second Amendment. I think the court's going to eliminate the exclusionary rule under the Fourth Amendment when there's police violation of the search and seizure requirements. I think we are going to see the overruling of Roe versus Wade, and I think we're going to see the elimination of affirmative action. I think we are going to see a period of intense conservative judicial activism.
On that cheerful note, before I have us thank the panel, I just want another round of applause for the staff of the Barclay and UCI. And now, mark your calendars for next year. We'll be back for the 9th annual Supreme Court Term Review. Please join me in thanking our great panel.